SJC-10591, Commonwealth versus Samuels.
Ms. Foster? Good morning, Ms. Foster.
Good morning, Your Honors. May it please the Court, Chris Foster for the Commonwealth. The Court should set aside the defendant's current sentence of 15 to 18 years and remand it for sentencing pursuant to the 1993 version of the home invasion statute.
Does it not concern you that you've changed positions?
It came to the Commonwealth's attention a little over a year and a half ago that the defendant was serving a legal sentence. The fact that the Commonwealth at the time mistakenly believed that the defendant had to be sentenced under the 1998 version doesn't nullify the fact that the Commonwealth can't assent to an illegal sentence. The defendant's sentence is illegal. The 1998 version of the statute contains substantive amendments to the 1993 version. Specifically, it created two theories or avenues under which the Commonwealth could prove armed home invasion. Substantive amendments are considered implied repeals, which are governed by General Laws, Chapter 4, Section 6, second. And under Section 6, second, a punishment is incurred on the day the defendant committed the crime.
So I'm sorry. Let's assume that you're right. Let's assume that it was illegal at the time. Let's assume that he completed his sentence and is out on the street. You would say it's appropriate for the Commonwealth to say, "Oops, we made a mistake at the time of sentencing. We failed timely to appeal from the appellate division's decision, and now it's both fair and appropriate for us, many, many years later, after he's returned to his life, to say, no, you actually need to serve 8 years more."
I think that's an extremely different situation. The only time I have found it to be fundamentally unfair or shock the conscience is when the defendant is released. The only cases that my sister and I have cited for that are DeWitt versus Ventitulo and Commonwealth versus Lye. In both of those cases, the defendant had been released, had become a productive member of society. And if you look at DeWitt versus Ventitulo, that court specifically stated that this is unlike the situation where the defendant is still incarcerated. The court will look at whether it's an extreme situation where there's a significant change in circumstances. The only cases I have found where it is considered a significant change in circumstances is where the defendant is released. I would direct the court to one of the cases I cited in my 16L letter, Lerner versus Gill, which I think is very similar here. There, the defendant was found guilty of 2 counts of murder. At the time, I believe it was the Attorney General's office, thought that the defendant could serve these concurrently, which meant in 10 years he could be up for parole. 7 years into his sentence, the Attorney General's office agreed again that in 3 years he could be up for parole. Once he started filling out parole applications and was having parole hearings, the Attorney General's office realized he could not serve concurrent sentences, that they had to be consecutive. So at that time, the Attorney General's office had him basically serve another 10 years. At that time, when he was up for parole, he was in a pre-release center. He had work and furlough privileges. His family had even moved closer nearby and opened up a business, so once when he was out on parole, he could have employment.
Ms. Foster, let me ask you this. You can read the rules, correct?
Yes.
Do you think filing a 16L letter is the appropriate way to bring to the court's attention cases that were published years beforehand that you just happened to come across when you did a little bit more research?
Yes, I think the 16L doesn't require that these be new cases. They just have to come to the attention of the Commonwealth or either party before argument. And
so why do you think we have timely briefs and allow one party to know what the other party is going to say, that they can then respond, and then we have reply briefs? So we're just going to have endless rounds and rounds of appellate advocacy?
No, and in my brief, and I believe my reply brief, I do cite examples of where after the defendant began serving his sentence that he that the state or the court realizes the defendant was sentenced improperly, and then they call him back in and increase the sentence. In those cases, it was a shorter period of time, so I submitted these cases not as a new argument, but just to be more illustrative of the fact that...
But it doesn't answer my question. So now do we give time to opposing counsel to respond, and then you want to have a reply 16L later?
No, I just think that the point of 16L is to inform the court of authority that has come to my attention after...
I would suggest that that is an extremely erroneous reading of the rule, that you expect to do the research and write your brief based on the existing case law, and on occasion you can file a motion asking to bring to the court's attention, but we really don't have just open-ended, rewrites of briefs.
And I would disagree that this would be a rewrite of my brief. These are just a couple more examples of the fact that the Commonwealth, that the court
to which the defendant has not had an opportunity to respond.
I believe in this case my sister did file a motion to strike.
Well, she filed a motion to strike.
If the court so wants, they may. I still think, even without my 16L letter, the cases I've cited demonstrate the fact that the defendant doesn't have an expectation of finality in an illegal sentence. He can have his sentence, the court must increase his sentence to bring it into conformance with the law. So regardless of my 16L letter, I think that it still shows that due process wouldn't be violated. The only cases I have found where it is a violation of due process is when the defendant is released. And I think those are the only cases cited by my sister as well.
And what do you claim was the abuse of discretion or error of law of the single justice?
I'm not sure, obviously, why Judge Cordy denied the Commonwealth's motion or petition. I believe it could be under one of two reasons. One, that we have somehow waived our right of appeal, or that we have waited too long, or something along those lines. If the court thinks we do have some avenue of appeal, the Commonwealth would...
No, you're here appealing a single justice's order, and you have to demonstrate to us that he abused his discretion or there was some other error of law.
I think it was an error of law because a defendant cannot serve an illegal sentence. I bring to the court's attention cases cited, I believe, on page 7 of my brief, Commonwealth v. Cowan and Commonwealth v. Rotunda. In those cases, they say that the Commonwealth, the people have the right to expect that this court will correct an illegal sentence. Once the Commonwealth realized that the defendant was serving an illegal sentence, we went back to the court with final jurisdiction here, which was the appellate division. We petitioned for them to reconsider, considering the fact it is an illegal sentence, and they denied us. So we came here to the court of last resort to bring the defendant's sentence to a lawful sentence. I think the Commonwealth was duty-bound once it discovered that the defendant was serving an illegal sentence.
It may have been duty-bound to go back to the court that had jurisdiction over the matter, but why does it have to bring a special proceeding under our very strict rules, and you still haven't shown me where the single justice has abused his discretion?
I think he's abused his discretion because the court can't enforce an illegal sentence. I think the fact that he denied the petition, it could either be because we have another avenue of relief, which I believe we don't. We did try to go back to the court with final jurisdiction. And so either it was denied on those grounds, and if we did have an alternative avenue, then I'd like to know what that is, and we'll follow that. And if not, then I think it was an error of law for the single justice to deny this because he is serving an illegal sentence. And I just want to touch upon one more thing, that double jeopardy wouldn't be violated. Again, here it's whether he has an expectation an expectation of finality in his sentence. And I think it's really well settled that a defendant can have no expectation in an unlawful sentence. And if you look at DeWitt versus Ventatula, which my sister cites, one of the factors the court can consider is whether the defendant is the reason why his sentence was reduced to below a minimum to an illegal sentence. And here it was the defendant. He's the one that moved to have his sentence reduced on 2 different occasions.
Thank you, Ms. Foster.
Thank you.
Ms. Mencken?
Good morning. May it please the Court. Michelle Mencken for Henry Samuels. So the Commonwealth's basic position is that, number one, the sentence is obviously illegal, and number two, an obviously illegal sentence can't stand, so this Court is obligated to entertain this petition and undo the sentence. And respectfully, the Commonwealth is wrong on both counts. This sentence is not obviously illegal, as evidenced most clearly, I'll just mention at the outset, by the fact that the Commonwealth previously reviewed the legality of this sentence and came to the opposite conclusion and determined that it was a legal sentence, and so advised the Superior Court, and didn't appeal it, didn't seek any review of it. That was their position.
Could I just ask you on that point, you argue that, quite apart from a sort of estoppel or laches basis, that as a legal matter, if the law changes before a defendant is sentenced and the change would be beneficial, that is, it's lowered the statutory sentence range, that it's not impermissible to give that benefit to the defendant. Is that these cases dealt, I'm sorry, I haven't had a chance to read them, do they deal specifically with that question, the ones that you cite, like Aldopoulos?
Well, actually, Aldopoulos, no. The principle is mentioned sort of in the discussion in dicta in Aldopoulos. It doesn't stand for that principle. The earlier cases, and it's interesting that Justice Gantz was invoking Justice Shaw earlier, because there was a body of case law from the 1800s developed substantially by Justice Shaw that did deal directly with this principle. So if it became very clear that if just the penalty provision of a statute was amended, that the amendment ended up being beneficial to the defendant, and this is prior to sentencing in these cases, that the defendant was entitled to the benefit of the mitigating statute. And those cases have been picked up in cases such as Nassar and Patrick, dealing with this general savings clause that's on the books in Massachusetts. Incidentally, that general savings clause went into effect in, I think, 1836, before this body of case law that discussed the penalty, the mitigating penalty doctrine. And it has withstood the test of time, as noted in Nassar, where they say, well, we have this general savings clause, but the modification of the statute that we're talking about here, it is not the sort that just affects penalty, such as Wyman is.
Now you don't cite Nassar, is that? Do you? What? Am I looking at the right? I'm looking. Okay. Well, maybe you'll just give me the site.
Well,
oh, yes, you do. You do. You don't have it in the index, but you do. I see it.
I apologize for that omission. In any event, the other thing that body of case law did was make it clear that there's a distinction between these amendments to the penalty provisions of the statutes and complete repeals. And there are a number of examples, such as Wyman, Gardner, other cases cited in the brief, where sort of the amendment takes the same statute, adds language that divides the offense into various degrees, and the defendant, whose case is at issue, becomes subject to a mitigated degree of penalty. That has been called a mitigation that is not barred by this general savings clause. So that principle is clear. The narrow question, if this Court were to look at the legality of the sentence here, is whether that doctrine would apply to a person who had already been sentenced, but whose sentence is open on appeal. And so that really is a question of line drawing, for which this Court would have to look at legislative intent. The intent of this amendment is difficult to discern. It was part of an act to control, let's see if I can find the exact title.
it's a statute and the amendments that has been the subject of a number of cases.
That's
so.
right. In this Court's recent Zapata decision, I think you observed sort of the tumultuous history of this relatively new statute.
Star-crossed statute.
So I would suggest to this Court that because of that history, this may not be the case to resolve the question of whether of the application of the ameliorative sentencing doctrine to a case where the person has already been sentenced, but the sentence is open on appeal and there hasn't been a final mandate by the appellate court, although that may be an interesting issue to flag for the legislature to make clear their intention with respect to retroactivity should the legislature decide to, for example, overhaul the drug laws in a manner that mitigates penalty. But I would urge the Court that for the many reasons set forth in the defendant's brief, that issue shouldn't be reached in this case because of the Commonwealth's obvious waiver, not just the passage of time, which does in fact implicate double jeopardy concerns. And I'll point out that in the case of Lerner v. Gill that was just cited by my sister and which was in her post-argument letter, the whole reason that case came about is because of a mitigating sentencing amendment. The person had been sentenced with serving time, during trial, I don't want to misstate it, there was a mitigating amendment that reduced the amount of time that the person would have to serve before reaching parole eligibility from 20 years to 10 years. And there was no question in that case that the person was entitled to the mitigated penalty. So that the Commonwealth is just incorrect that the penalty is incurred at the time of the offense. That's not the law of this Commonwealth. So there's no abuse of discretion by the single justice in determining that this is not an extraordinary case for relief the Commonwealth has had. It's not as if this is a case where there was some mistake committed by the Department of Correction, for example, that was not fully vetted in a court of law, and the defendant was actually just holding his breath and hoping to maintain the benefit of this error. That's a different case than the case here where it was brought, briefed, researched, discussed in the prosecutor's office. A position was reached, a decision was reached. Again and again, it was revisited, and the Commonwealth never raised it. And so that is the reason that they don't have any other avenue of relief right now. But that means that they've forfeited it. They've invited the error that they're complaining of now. And they have no right to appeal it to this court under 211(3) or any other mechanism at this time.
Mr. Mencken, Ms. Mencken, this may not be entirely relevant, but you did attach to your brief the classification report. Could you tell me what an OBS is? His OBS is 5. If you don't know, don't worry.
OVS. I know
OB for boy.
OV is official version.
Doesn't matter. If you don't know
I'm
off the
sorry,
top.
I don't know off the top of my head. If you wanted to refer me to the page, I might be able to look and see.
It's the last thing that you attach on page 39 of your brief. But I thought you might just know. But if you don't,
I apologize. I don't.
It's not a problem.
So if the court has no other questions for me, I'll rest on my brief.
Thank you.
All right. Hear ye, hear ye. All persons having anything further to do before the Honorable, the Justices of the Supreme Judicial